language is taken directly from Amendments 4, 5, 6, and 8 with my commentary. Amendment 4, 1791. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. The ban on unreasonable searches and seizures is one place where the notion of privacy appears in the Constitution. The word itself is nowhere. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Courts cannot issue arrest or search warrants without a sworn statement justifying them. Amendment 5, 1791. No person shall be compelled in any criminal case to be a witness against himself. This is where the notion of pleading the fifth comes from. Amendment 6, 1791. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. The Sixth Amendment has rules aimed at making sure criminal trials are fair. And to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 8, 1791. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This is where the death penalty debate plays out. This chapter is about crime under the Constitution. The framers of the Bill of Rights cared a lot about fairness to criminal defendants and justice for victims, as demonstrated by the fact that 4 amendments to the Constitution addressed the topic. But it's not just the people who wind up prosecuted for crimes who will find protections in the Constitution. It's anybody who lives in America and doesn't want the government peering into his or her personal business. The Constitution draws some very clear red lines here. It won't let the government knock down your door and rifle through your stuff willy-nilly. Nor does it let judges give the go-ahead for that kind of thing by issuing a warrant without having a certain kind of evidence first. It won't let the government trump up charges against a political dissident and throw her in jail indefinitely. The Constitution contains language that won't let the government torture prisoners into confessing to stuff they didn't do, or force people to make statements that could land them in jail, and so on. Only government, not regular people, can press charges. Nonetheless, there are times when the government forces reluctant witnesses to take part in a prosecution against their will. As you know by this point, when the Constitution says thou shalt not do something, it needs consequences. There are bad cops, bad prosecutors, and bad judges, and cops, prosecutors, and judges who make mistakes. By affording individuals specific rights in the 4th, 5th, 6th, and 8th Amendments to the Constitution, the framers put tools in each of our individual backpacks of rights, which we can take out to stop the government from doing something it isn't supposed to do. How are these tools employed? Sometimes we can sue for money damages. Sometimes the evidence won't be available to the prosecution. That is, a defendant can file a motion asking the judge to throw out a case or to ban the government from presenting certain evidence to a jury on the theory that, for example, the 4th Amendment was violated when the government searched the accused's iPhone and found incriminating documents. The Supreme Court held in 2014 that the police usually need a warrant to search data stored on a cell phone. Sometimes the government violates your privacy, and even though they can't use